First case is Bark versus State. Counsel can begin when you're ready.
May it please the court, I'm Dan Senior. I represent Fred Bark here. He's the appellant. He was a defendant in a criminal case below. I was not the trial attorney. And there's really three issues in this. Excuse me, I'd like to reserve 5 minutes too.
Okay, try and help you keep your time.
There's really three issues in this case. I think any one of them would result, hopefully, in a reversal or a reduction of the conviction. This is the case, as we put in our brief, a man is brought to an emergency hospital because of overdose of medication. Overnight, the next day, up until it's almost noon, he's still unconscious. They have him in restraints, so when he wakes up, in case there's any thrashing about, they give him additional medication, have tubes in him, a tube down his throat, all kind of problems. He wakes up. During that entire time, a male nurse is trying to communicate with him and cannot. When he finally wakes up, about within 10 minutes, he's thrashing about trying to get out from whatever he's under, whether it's a pink elephant or a wild tiger or the restraints that he doesn't know. And during that thrashing, he kicks out, and a second nurse who had come in to help restrain him is struck in the eye. Based on that, the government, the state, gets a criminal felony conviction of him knowingly and intentionally battering a nurse at the hospital when there was no evidence that he even knew she was in the room. There was no communication between them. She was in plain scrubs. He had never spoke to her. He had never seen her. He had not communicated at all with the nurse that had been with him all night and that morning. And there was, at the trial, the judge was asked to reduce it to a simple battery and that there was no knowledge that she was a nurse. He considered that, but then rejected that and let it go to the jury. The first issue is my client did not have the intent, knowledge of where he was or what was happening. And I think it's a sad day when any of us go to a hospital, we're unconscious, and within 10 minutes of waking up, hours and hours later overnight, and we're restrained because people do thrash about, someone gets struck, that becomes a criminal felony. That's not my version of America.
Mr. Stainer, were all those facts given to the jury?
They were.
Tell me why we should step in and act as a seventh juror.
Because that's the wonderful function of an appellate court. When a rogue jury, for whatever reason.
Rogue jury?
Rogue jury.
How do we know it's a rogue jury?
Because I am arguing that no jury, understanding the real situation there, would have found that a man opening his eyes 10 minutes after being unconscious all that time, with all that being restrained in advance while he's unconscious, because they know people thrash about, then thrashed about, and a woman was struck. I'm arguing this. I submit if it was a child that had been restrained, we wouldn't even be here. But because there's a grown man and apparently an attractive nurse, and she's struck in the eye, that may be some kind of civil action or something, but to make it a felony crime, I think is improper. And I asked the court to...
Was the jury improperly instructed?
The jury should have been instructed only to find a battery verdict, Judge.
That's a matter of reducing the charge.
I'm talking about as far as the instructions, the standard instructions were used, Judge.
Assuming the trial judge did not feel it was appropriate to reduce the charge, was there any problem with the instructions?
No, sir.
And the jury considered all of those facts? Considered the notion that, quote, he looked her in the eye and cold-cocked her, and considered that she was wearing nurse's scrubs at the time? And you're saying that no reasonable jury could have concluded that a felony was committed?
It's my argument that at best that would be circumstantial evidence, and the law is it must exclude a reasonable hypothesis of innocence. There used to be a special jury instruction, which they did not receive because it's not now a special jury instruction on circumstantial evidence. In other words, the state, 10 years ago got that so they could get more convictions, obviously, and it said reasonable doubt covers all that, but the jury never was instructed on that point, okay, nor was it argued, okay, because we're not allowed to do that. We want to get up and say, well, if there's two possibilities, even if one is greater, it must exclude any possibility of innocence. We don't get to argue that anymore. And so the jury says, obviously, the foot hit the eye and she's a nurse. Bingo. Why are we here? Okay? And that's why we're here. The other thing is, Judge, there was a
Senior, let me ask you this: I guess the trial judge really sits in the capacity of the seventh juror and had an opportunity to hear the argument on a motion for JOA or a motion for new trial. Is that correct?
Yes, sir.
All right. And now we're going to review that trial judge who has some discretion in deciding whether or not to grant that relief. What is our standard of review?
I think the standard is de novo at this point. Under my understanding of the law and the cases I've cited in the brief, you get to be the ninth, 10th jurors. That's why they set that up in a case like this when we have this kind of a circumstantial situation. And I'm saying that we're finally with people who are not seeing what the parties look like or not knowing anything other than what the record shows, and we have dispassionate people that can rule that the jury shouldn't have brought that verdict back. I would bet a lot, but you're not allowed to bet in criminal cases. A next jury would not find a felony conviction. Not if I'm a lawyer, and I'm going to be if I get that chance, because this is not right. The other problem is that I think the judge, now I'm not clear on this, Judge.
Suppose that the next jury does find him guilty. What are we going to do then? Just do this all over again until you get an acquittal?
No. But I think you should have that chance. I think anyone in the hospital in those circumstances should have that chance. When he's been medicated, he's being there because he's got too much medication. They give him more medication, and the nurse throughout the night communicates not at all with him. And he does what people do. They thrash him out, and someone got struck. That's a felony crime? The jury says it is. I think what might have happened is there was an offer from the state, and the person didn't accept that. And I think there might have been a little we'll fix you type situation here.
Is that in the record?
I'm not positive if the offer.
Let's not talk about it.
All right. Okay. The other question is the sequestration of the witnesses, in that the alleged victim nurse, that we didn't know was a nurse, was allowed to sit in while the other nurse testified as to the whole sequence of events, including while she was there. There was an objection, and there's a constitutional right, obviously, for cross-examination of witnesses, Sixth Amendment, United States comparable Florida Constitution, and there's a statutory right that a victim can be present, but there has to be a hearing that there's no prejudice. The defense attorney said to the judge, well, look, we object to her not being under the rule, but if she's not going to be and she's allowed to be in here, call her first. And there was no reason they couldn't have done that. So both sides could have got the benefit of it. But this way, the state didn't call her first, let her sit in while the first witness testified, and then she was allowed to testify. So his constitutional right was violated and the statute wasn't complied with. And that just, I'm asking the court to say that there must be a hearing like the statute says, like the law says, and when the witness can be called first, then there's no prejudice to either side. It should be done that way, and it wasn't in this case. I'm asking you to rule on that. It's in some writing and some guidance to the lower trial courts. So for each and all those reasons, first, it should have been reduced down to a simple battery because he didn't know she was a nurse. If not, it should have been a judgment of acquittal. And if not, because of the lack of evidence and the other errors, I'm asking it to be reversed for a new trial with an impartial jury. I don't know my time.
You've got about 6 minutes and a half.
Thank you.
May it please the court, my name is Bonnie Parrish. I represent the state of Florida in this case. If this court has no questions, I'll rely on my brief and ask that you affirm the convictions in this case.
What do you think our standard of review is?
On the judgment of acquittal, well, Pagan says the standard of review is de novo. I don't believe it's de novo of the jury's verdict. I believe it's de novo of the ruling on the motion for judgment of acquittal. And in this case, the two issues were intent and knowledge.
What do you say about Mr. Steiner's argument that on the sequestration issue, that since you have the opportunity to call the victim as the first witness and preserve the victim's right to stay in the courtroom while preserving the defendant's right to sequester witnesses to enhance the truth-seeking component of the trial, that that's really what the court should do when it has that opportunity.
Maybe that is what the court should do. In this case, first of all, the prejudice argument that they make in this case was not made below. His whole objection was that the Constitution and the statute only allow the victim to be present for other hearings, not during the trial. That was the whole objection. Never argued any prejudice.
Well, isn't that implicit in the objection?
I don't believe so, no. I mean, this victim, this case, there were two state witnesses. They were the eyewitness and the nurse victim, who was also an eyewitness. When she got on the stand and testified after the first nurse testified, they could have cross-examined her, impeached her, brought in statements that showed that she altered her testimony to conform with the first witness testimony. There was none of that. There was nothing to show that this witness changed her testimony because she sat and listened to the first one. Maybe in a perfect world it would have been better for her to go first. In this case, considering that it was two witnesses, both who were present in the room when the crime was committed, I really don't think it makes much difference in this case.
Sequestration is a trial right, though, that the defendant enjoys, isn't it?
Yeah, it's a court-created rule.
And it's, you know, there's no requirement that the defendant, in order to invoke the rule of sequestration, show that there's prejudice as a condition of invoking the rule, right?
Not as a condition of invoking the rule, no. But when he objected to the victim remaining in the courtroom, yes, he needed to make that argument. He didn't make that argument. They just didn't want her sitting in there.
So are you saying the argument was waived, or are you saying it was harmless error?
I'm saying both. I'm saying I argued it was harmless, and I'm also arguing that as far as the prejudice part of their argument is, that they didn't make that, it's waived.
Can you apply a harmless error analysis to a constitutional right?
I don't think that there's he had no constitutional right. The rule of sequestration is not a constitutional right. You can apply harmless error to constitutional rights, yes. But that's not what this is.
Yes, you can.
Yes, yes. If there are no other questions, I would ask that you affirm the convictions in this case. Thank you.
Thank you, Mr. Harris.
Quickly reply that clearly the Constitution would cover that, first under the right to effectively cross-examine a witness, and second under the due process clause. We know from traditions from way before any of us were even in the bar that the rule of sequestration has been used until this new statute allowing victims' rights to come forward. There was never any argument on any side about it. It was the proper way to try cases if either side requested it or the judge on his own wanted to sequester the witnesses, and it was specifically asked for and then said if she was going to get her statutory right, have her called first. So they could have had it both ways, but they chose to deprive the defendant of his right, and I agree with Judge Griffin. That's implicit. We all know. We don't even have to say, may we invoke the rule of sequestration. We just say we'd like to invoke the rule, and everyone in that courtroom that's got anything to do with law knows what we're talking about and why we're doing that. And it should be done.
Did counsel below suggest to the judge that a reasonable compromise or balancing of the interests would have been what you have advocated to us?
He did implicitly by saying, well, look, why don't we call her first? And that was overruled. So he gave them the choice that they could have had it both, but they specifically said, too bad. No. Okay, and the other point I want to point in the file.
Hold on for a second. So what you're saying is that there should have been a hearing first.
Absolutely.
And if the judge had the hearing and then decided we're going to let the victim stay in, that would have been okay.
It depends on why he would have said that. No, we still wouldn't have wanted. Obviously, but the judge has the final call. There's no question. But he should at least have a hearing and determine that, not just said state wants her first and the state doesn't want to invoke the rule. That's that. In other words, the defendant gave them a way to satisfy both sides of the issue, but they wouldn't do that. The other thing I'd like to point out, just to reply, Judge Monaco, to what you said about this when she was struck in the eye. Again, the testimony looked at her. No testimony ever saw her. Might have saw a pink elephant. Might have saw some giant holding down in a cave. We don't know what he saw. Okay, they might have been looking at the spot in the wall behind her, or might not have seen her at all. So she was struck, but that's not an intentional battery of a known hospital worker felony. So I ask you on both issues, please, and especially on the sequestration rule, please reverse this, explain to the judge what should be done, and give us another chance with a real jury. Thank you.
You know, before you sit down.
Yes.
Back to the sequestration issue. Respond to Ms. Parrish's argument that there was an opportunity to demonstrate through cross-examination some inconsistency in her testimony, but there was no inconsistency that was shown, and therefore there's no showing of prejudice. In other words, that this is not a harmful error.
The reply would be the hearing would have to be before they invoke the rule. In other words, it's denied, I'm sorry. Back when he said we'd like to invoke the rule, if the state comes forward and says, well, they need to show some kind of prejudice, no one raised the issue of prejudice at the trial. The judge just flat said, we're not doing that. You don't get the rule of sequestration.
I'm talking about an appeal. I need to find a harmful error. How can I say this is a harmful error?
It's a harmful error because the constitutional right. Okay? I have to concede there was no testimony about the harmfulness of it. But I think that's implicit in the rule, is what my argument is. That's why we invoke the rule, to make sure there is not one.
So this has to be a per se error.
When the defense side or the other side in any case says, call her first so you can have it both ways, I can still have my client for protection, and you can still have the victim there the whole time, I would ask if that's what's required, it definitely should be a per se rule.
Okay, thank you.
Thank you, Judge.